Okay, well, let's get underway. So on behalf of Baker McKenzie, welcome and thank you for joining today's webinar, Litigating Designs, All You Need to Know in the Asia Pacific. My name is Helen McPherson and I'm a partner at Baker McKenzie in Sydney. This is the first in a series of 4 webinars looking at design litigation across the globe. In the following 3 days, there will be sessions in Europe, North America and Latin America. If you are interested in attending these other sessions, details will be provided at the end of this presentation. Before we get started, a few housekeeping notes. To ask or submit a question, please use the Q&A box at the bottom of your screen. We will address questions after the presentation and we'll do our best to get to all of them. If we can't get to your question, please get in touch with us, any of us, after the webinar. To confirm your continued participation and eligibility for the CPD points offered in this webinar, please complete the polls that we will be launching periodically throughout the session, as well as the evaluation forms that will be provided in the follow-up communication. Finally, this session is being recorded and webinar materials will be shared with you after the event. So over the next hour, we will be discussing design rights. Design rights can often be a valuable cause of action when challenging the use of identical or similar features in products by competitors or counterfeiters. The agenda for today's session is on the screen. I'd like to briefly introduce my colleagues for this webinar. Joining me are Abe Sun from our Singapore office, Victoria Bell, my colleague from Sydney, Binshin Lee from our Fensham team, and last but not least, Joanna Ouyang from our Taipei office. So let's kick off the session with the first polling question, and that is, does your organisation actively pursue registered design protection? So I think we'll see the results soon. Okay, so there are the results. It's almost a, well, 50-50 split with 20% of people saying they don't know. So it's an interesting mix. So look, on that note, I will now hand over to Victoria and Abe to talk about the protection of designs.
Great, thank you, Helen. Hi, everybody. My name is Abe Sun. For this first session, my co-presenter, Victoria Bell, and I will briefly introduce registered design protection in the Asia-Pacific region. Our topics will include what can be protected by registered designs, are there differences in design registration and pre-enforcement in the Asia-Pacific region, and 3 potential pitfalls to take note of when it comes to registered designs in the Asia-Pacific region. Now, due to the shortness in time, we will only be able to briefly touch upon these topics, but please feel free to reach out to any one of us after the session should you require more information on registered designs or any other form of intellectual property protection. So let's begin. As you all know, there are various forms of intellectual property available to protect products. For example, here in the Asia-Pacific region, there are trademarks that can be used to protect particular shape marks, provided that the shape of the product can serve as a source of origin of the product. Certain aspects of the packaging of the product can also be protected via trademarks as well. Then there's copyright that can be used to protect features or visual representations of a product. But it should be noted, however, that certain jurisdictions, such as Australia, do not permit dual protection for works that are industrially applied in 3D form. And then there's also patents, which can be used to protect novel and inventive functional features, shapes, and/or compositions of a particular product. Other actions, such as unfair competition, misleading and deceptive conduct, and/or passing off actions, can also be taken against those who are commercially copying features that characterize your product and or your packaging. And of course, finally, there's registered designs, which we will focus on today. So for the benefit of those who may not have had much exposure to registered designs is a form of IP that can be used to protect the visual or aesthetic features of a product and or its packaging, including two-dimensional features of pattern or ornamentation, as well as three-dimensional features of shape or configuration. So to be a little bit more specific, registered designs can be used to protect the visual features of a product or even a set of products that either share a same design or have a same design with modifications or variations that are not sufficient to alter the character or substantially affect the identity of the product. Registered designs can also be used to protect complex or composite products, including those that have multiple components. An example would be a kitchen unit having a sink, a set of drawers, and other components as well as a combination or set of products. Registered designs can also be used to protect parts of a product in certain jurisdictions. So a headrest of your office chair is an example of parts of a product. Get-ups, ornamentation, graphical user interfaces, and product packaging are some other examples of what can be protected by registered designs in certain jurisdictions in the Asia-Pacific region. So as we will further touch upon in the next few slides, protection of registered designs is not uniform across the Asia-Pacific region. For example, certain jurisdictions such as Thailand and Vietnam do not allow for protection of parts of a product. Next slide, please. Pursuing registered design protection in the Asia-Pacific region starts with the filing of a design application. It is important to note that there is presently no such thing as a universal design application that protects you in all jurisdictions in the world. So in order to obtain registered design protection, you will need to file an application in each and every jurisdiction that you want protection. And obtaining design protection is generally quite quick, easy, and low cost as compared to other forms of IP, such as patents. So as mentioned earlier, registered design protection is not uniform across all jurisdictions in the Asia-Pacific region. So for example, certain jurisdictions such as Indonesia, Vietnam, Thailand, or even Taiwan will perform substantive examination to assess the requisite novelty of a design before it is granted. But most jurisdictions in the Asia-Pacific region will only perform what is called a formalities examination without first determining whether the design meets all substantive registrability requirements. So for such jurisdictions that do not perform substantive examination before grant, registered designs are still useful in that they oftentimes serve as a deterrent against competitors and infringers. So for example, any competitor who may consider commercializing a product in such a jurisdiction that doesn't perform substantive examination, if they do come across your registered design, they will need to consider whether they want to take the chances that they may be held liable by a court of law of infringing your registered design. To reduce such chances, these potential infringers, they'll need to first assess such risks by engaging an IP lawyer to perform due diligence, such as what we call a freedom to operate or an FTO, which may be costly and time-consuming as well. So after a registered design has been granted, an owner of a registered design will generally have the right to enforce against an infringing product. But one thing to note, though, is that there are certain jurisdictions, such as Australia and China, that require registrability or patentability assessment reports that are certified by their respective patent office before enforcing against an alleged infringer, which can also take time as well. As another example of inconsistencies among jurisdictions in the Asia-Pacific region, some jurisdictions such as Taiwan, the Philippines, Vietnam, and soon to be Singapore this time next year also offer customs notices for designs as well. One thing that is consistent, however, amongst all jurisdictions in the Asia-Pacific region is that there is currently no protection available for unregistered designs across the Asia-Pacific region. So please do consider pursuing registered design protection in those jurisdictions that are commercially important to you. I'll now hand over to Victoria to introduce some potential pitfalls to take note of when it comes to registering designs in the Asia-Pacific region.
Thank you, Abe. Good afternoon, everyone. When planning your filing strategy, it is important to keep in mind what are the key features of the design that you wish to have exclusive rights to, and how best to protect them. In this process, we have identified some common pitfalls that I will now discuss. The first pitfall is the representations, choosing the right one. In particular, when you filed your first design application, carefully considering what representations you will choose, it's important. You have to keep in mind that some countries impose limitations or strict requirements on the form and the number of representations permitted to be filed with the application. In addition, some countries require a description of the figures that needs to be accompanied with the representations. It may be necessary to prepare a different set of representations to meet the requirements of the different countries of interest. Working with these requirements and constraints, the key consideration is ensuring that the representations clearly show the key features of the design. The representations will determine the scope of the rights granted, and the courts will decide the issue of infringement by comparing the infringing product against the representations accompanying the design registration. Some of the things to consider are, for example, where there is an option, whether it is best to file line drawings against computer-generated renderings or photographs. Even if line drawings or computer-generated renderings are filed, where possible, consider filing a photograph of the actual product or a product prototype. This may assist in interpreting the design at the time of enforcement. Some countries may accept a photograph be filed for exemplary purposes. Importantly, color is also a visual feature that is protected by a design registration. And so is, for example, transparency or opaqueness. So the applicant should turn her mind to whether the protection of color, transparency, or opaqueness is imperative. Otherwise, filing line drawings in black and white will generally give a broader enforcement scope. Now, next slide. We come to the second polling question. Do you know how long registered design protection lasts in your key jurisdictions? The responses should come shortly. Well, it's good to see that there is majority knowing what the terms of protection are in your key jurisdictions. Because as we have mentioned before, there is no uniformity across the region on the terms of protection, and different countries set up different terms. Moreover, unlike trademarks, registered designs have a specific period that cannot be renewed. So it's important to know what period that is. If we go to the next slide, please. A second pitfall is the lack of understanding that to obtain design protection, pretty much all countries around the world require the design to satisfy a novelty threshold. Publishing a design before filing could be fatal in countries where no grace period for general publication is available. As a result, it is preferable to keep the design confidential and avoid publication prior to the filing of a design application. Disclosure of a design prior to filing the design application should only be made under confidentiality terms or memorandums of understanding. The novelty of a design is tested against the prior art base for the design. In most countries in the Asia-Pacific region, the prior art base includes any designs published anywhere in the world before the priority date or filing date of the design application, whichever is earlier. The novelty test varies across the different Asia-Pacific jurisdictions. Generally speaking, all countries require the design to be new. That is, not to be the same as a design previously disclosed in the prior art base. Some countries also impose a second requirement. For example, that the design is also original or distinctive or not obvious. Given this diverse approach, a design may be found to satisfy the novelty requirements in some, but not all the countries. Care, therefore, should be taken when considering protection of iterations or different embodiments of the designs. Unless the various embodiments are filed at the same time, new iterations or embodiments of the design filed after the first version has been filed may not satisfy the novelty test. There is another risk that filing for different embodiments could result in narrowing the scope of enforcement of the first design. In countries where design protection is available for parts of a product, the use of dotted lines in combination with statements of monopoly could achieve the desired outcome of protecting specific features of the design that are likely to be copied by competitors or that differ in the various embodiments. Now I will pass over to Abe to discuss publication and grace periods.
Great, thank you, Victoria. So in view of the shortness in time, I'll just briefly touch upon grace periods. So as Victoria had mentioned, novelty is an important requirement for registrability of designs. Any public disclosure made prior to the filing of a design application can potentially be used to destroy the registrability and enforceability of a registered design. Most jurisdictions in the Asia-Pacific region will provide a 6-month grace period for public disclosures of designs made prior to the filing of a design application. What's important to note, though, about grace periods is that most jurisdictions will only provide for such grace periods in certain limited circumstances and exceptions. For example, grace periods may only be available for certain public disclosures made by the designer or the owner themselves, or a person that's authorized by the owner to do so, or through, for example, unlawful disclosures, such as a disclosure made in breach of a confidentiality or non-disclosure agreement, or even public disclosures that are made in a government-sponsored international exhibition, for example, or certain examples of certain limited circumstances and exceptions. In situations where a competitor has used a similar or same design before you file a design application, there are a few scenarios that's worth discussing. So in the first scenario, if such use by a competitor is not considered as a novelty-destroying public disclosure, this may not affect the registrability of your design, and therefore your registered design may remain valid. So that's from the registrability perspective. So now from an infringement perspective, certain jurisdictions in the Asia-Pacific region, such as Singapore and Taiwan, have a prior use exception, which serves as a defense against infringement of a later filed design application. So in such case, you will not be able to enforce your registered design against such competitors if such competitors can prove they independently came up with the design and used it before your filing. So that's the first scenario. In the second scenario, if such use by the competitor is considered as a public disclosure and novelty destroying, this could affect the registrability and enforceability of your design. Now, in a situation where a competitor files for design protection before your filing of a design protection, design registration laws across the Asia-Pacific region are consistent in that all rights will be given on a first-to-file basis. So if the competitor files the design application before you do, the competitor will have better rights to the design than you. However, for our particular example, if you previously disclosed your design before the competitor's filing, such disclosure will actually serve as prior art and destroy the novelty of your competitor's design application as well. Victoria, I'm wondering, would you like to share with us your position on grace periods in Australia?
Yes, thank you, Abe. Australia didn't recognize a general and doesn't recognize still a general grace period for disclosure of designs. However, legislation has been introduced and passed. And from March 2022, we will recognize a 12-month publication grace period. And similar rules as those that you have just discussed will apply in terms of priorities between publications of competitors or publications of authorized persons. Given the short time frame, I'm gonna go to the last, I'm gonna touch on the third key pitfall, which is defining the design and the product to which the design applies. So the monopoly granted in a design registration will be limited to the product or products named in the design application. And it is important, therefore, to consider carefully how to obtain the broadest protection by describing your product broadly or by filing a design application to cover more than one product. An example, for example, if a design is registered for a can it be enforced against a jar that incorporates the same design? It's one of the questions that you should consider when filing your application. Importantly, some Asia-Pacific regions do not consider graphic user interfaces, logos, or surface patterns to be products of manufacture. Therefore, protection for designs that apply to these products is not available. Other key issues quickly to consider is what is the key features the applicant want to protect? Is it a part of the product or a complex product? Whether the country permits protection of parts of a product or complex products? How are the courts going to interpret representations that include dotted lines, shaded areas, or blurred parts when enforcing that design in a jurisdiction that doesn't recognize protection for parts of a design? And keep in mind whether your design shows all the three-dimensional features and two-dimensional features that you wish to protect, because whatever is not shown in the representations will not be protected. Finally, possibly think of the advantages that may provide filing multi-design applications versus single design applications. In some countries, if you apply for the same design to a number of products that fall within the same Locarno class, no additional fees will apply. But if you apply for one design that apply a number of designs, including embodiments or iterations, even if they all apply to the same product, each different iteration or embodiment will attract an additional filing fee. Now I will hand over to Joanna and Vincent to take us to part 2 of the presentation. Thanks.
Thanks, Victoria. So in this section, Joanna and we will discuss about litigating design, some precaution measures and the means of defense. Okay, next one, please. First, I would like to discuss about the design coverage of competitors. So how to keep them on your radar and how to act against them. And for the first one, we will talk about some upstream measures which we can consider to enhance the design litigation. Next one, please. In order to build a good protection system for design patent enforcement, we should consider to monitor the market and the material competitors closely. So here we summarize 3 questions for everyone to consider, which is who to monitor, what to monitor, and how to do so. And for the first one, you need to consider and identify who is your competitors. And in addition to the competitors, you may also consider to monitor the partners and vendors, as we often see cases caused by partners and vendors who filed design patents in a bad faith or copy the design for their own products. So that's actually raised a big alarm on the market, and we should put them into your radar as well. And in terms of the product for protection, at least, I think you should consider to monitor for your most popular products and the most signature features of your product. And in terms of territory, in addition to your markets, you may also consider your competitors' manufacturing site and their market to put into your radar. And as to how to monitor, there are several searching engines for you to use, like PetSnaps and Packo, and Google in general is still a very good one to use. And another very powerful monitoring weapon is your local team. So who actually are in the front line and has the fresh access to the first-hand intelligence. And in our experience, many of the infringement intelligence actually came from the local team. Next one, please. And meanwhile, we also need to mitigate the risk of counterclaims. To avoid being at risk when with your own products and designs, how should we avoid such kind of negative impacts? Before you initiate a project or launching a product, you may check the source of your inspiration. And if a vendor involved, and you may also ensure it is contractually obligated with a non-infringement warranty as a mitigation of risk. And FTO is also is needed to bring further visibility on the infringement risk. So next one, please. And now I'm gonna turn to Joanna to talk about the second part. Joanna.
Thank you, Vincent. Now let's take a look at the enforcement strategy and the precautionary measures. Next slide, please. Before officially filing an infringement action, it is important to map out strategies first and take necessary precautionary measures so that a satisfactory result for the enforcement can be better secured. Firstly, we will need to assess the strengths of our design rights through prior art search and preferably to get a validity evaluation report before filing an infringement action. This is because the validity of the design right can be challenged in the infringement action by way of plea or counterclaim subject to the law of the jurisdiction. And we definitely do not want the outcome of our enforcement action is the design right itself being ruled invalid. We may need to amend our design right to make it more challenge-proof if necessary and applicable. Secondly, we will need to check whether we have put registered design notices on our products. In many Asia-Pacific jurisdictions, failure to do so may prevent a design right holder from claiming damages or render the design right holder to bear higher burden of proof with regard to the defendant's knowledge of the design when claiming damages. Thirdly, we would also like to take some pre-trial actions before officially filing an infringement action. For instance, we definitely would need to collect information and evidence regarding the infringing product, as well as its sales channels, buyers, price, and estimated sales figures. Some jurisdictions have evidence preservation proceeding that the design right holder can consider resorting to in terms of the collection and preservation of evidence. We may also want to send a C&D letter to the infringer first to establish intentional infringement, or to see how they respond and gauge the likelihood of resolving the dispute outside of litigation. We would also evaluate whether to apply for provisional or protective measures, such as provisional attachment and preliminary injunction. Lastly, we would need to decide where to bring the claim. Subject to the law of the jurisdiction, a claim may be brought in the court for the place of the defendant's domicile, principal place of business, or where the infringement occurred. Some jurisdictions like Taiwan have established a specialized court to hear IP-related cases, including design litigation. Available measures and remedies vary among Asia-Pacific jurisdictions. which include injunction, seizure of infringing products and materials, and various forms of enforcement. If the court rules in favor of the design right holder, it is common for the court to order recall, removal, or destruction of infringing products and materials, as well as to award damages. Legal costs, corrective advertising, and e-commerce platform takedown are also available in some AP jurisdictions. And so is customs enforcement, like detention of infringing products. Okay, next, please. Here comes a polling question 3. Do you actively monitor your competitors' products for design infringement? Okay, it's like an interesting mist. Yeah, but unfortunately, is that for almost 41% of our participants do not monitor the competitors very actively. It is worth noting that monitoring and acting swiftly in relation to infringements is key when it comes to enforcing your design rights, and an effective enforcement program often relies on an active monitoring element. Now I'll hand over to Bin-Sin with regard to the means of defense and alternatives.
Thanks, Joanna. So let's talk about defense. And in some of the jurisdictions, the non-infringement action is also available, which is we usually call it a declaration judgment action. And we can ask the court as an alleged infringer. We can ask the court for DJ action that the products or the do not infringe others' design. And why we do so? We take it as a proactive step to anticipate the potential infringement risk, rather than delaying the product launch until the design expired. And also, it provides certain certainties for the business who wish to launch their product to the market safely, or already launched, and but receive a complaint from a design patent owner. And where we can do so, it's a DJ action usually can be filed before court at the defendant's residence or where the infringement occurred. There might be a specialized court to hear such kind of complaint. For example, in China, there are IP courts and IP tribunals to hear this particular case. But please know that the availability, the procedures, and the principles vary significantly among all the AP countries. So for example, in China, after receiving a warning, the recipients could urge the patentee to sue or withdraw the warning. If the patentee does not make further actions after receiving such kind of response, then the recipients would have the right to file a DJ action. Otherwise, it cannot be triggered solely by the potential infringer. Next one, please. And almost across all the jurisdictions, we also have invalidation action available as a powerful defense weapon. Regarding the subject matters, there are many technical restrictions, which also vary significantly among the AP countries. However, there are some common restrictions. For example, the features of appearance of a product which is solely dictated by these technical functions of fine arts, the layout of circuits, or an article contrary to the public order or moralities. And invalidation attack also link back to the jurisdictions legislation. So but in general, novelty and the distinctiveness and also originality could be available as an invalidation grounds. Okay. All right, so this is the general invalidation action, the grounds. And for evidence, we also need to do a prior search, and also for invalidation actions, the quality of the proof is much more important. So usually, the evidence must have a clear disclosure date to be qualified as a prior design, and also disclose as many views as possible to have a full picture of the design. And usually the promotion materials and at current days, the social media could be a very powerful resources to collect such kind of evidence. So that's the end of my section. I would like to turn to Helen for the next one.
Thanks, Vincent. So, litigating design is the main dispute. So, when enforcing your design right, you're going to need to prove infringement, as you can see, but also withstand the inevitable invalidity challenge to your registered design. And this requires evidence. This means that in general, when it comes to enforcing your design right, you will need to prove that the allegedly infringing product embodies the design, or a design that is the same as or sufficiently similar in appearance to the registered design, with what is sufficiently similar depending on the legal requirements in the jurisdiction of interest, as you've heard from Victoria and Abe. In Australia, you need to prove that the infringing product embodies the design, or a design that is the same as or substantially similar in overall appearance to the registered design. And secondly, you'll have to withstand a validity challenge by arguing that the registered design is, again, sufficiently different compared to the prior art, with, again, what is sufficiently different depending on the legal requirements in the jurisdiction of interest. In Australia, the design needs to be new and distinctive, with the design being distinctive unless it is substantially similar in overall appearance to the prior art. So you can see the correlation, and if you move to the next slide. So you can see, and then I think one further. Thanks so much. So you can see the correlation between the infringement and invalidity analysis. In general, where a registered design departs substantially from the prior art, a product which does not differ from the registered design to a corresponding degree is likely to infringe. On the other hand, where the registered design differs only in small ways from the prior art, similarly small differences may be sufficient for the allegedly infringing product to be found not to infringe. So that leads us to expert evidence. And expert evidence is key to this analysis, and it's critical that you identify an expert with the appropriate experience and qualifications. The legislation and case law in your jurisdiction and the subject matter of the design and the use to which the design is put will guide the choice of expert. Each jurisdiction sets the bar for the person through whose eyes the questions of infringement and invalidity are assessed. It can be the informed user, in some cases it's the familiar person or the ordinary observer or the ordinary purchaser. These might seem like trivial differences or legal semantics, but they can lead to different outcomes. Until recently in Australia, we actually had two divergent lines of authority as to the characteristics required of the expert to assist in assessing distinctiveness for the purposes of infringement and invalidity. We had the informed user line of authority and we had the familiar person line of authority, with the familiar person being a person who is familiar with the product to which the design relates, or products similar to the product to which the design relates. Now, the informed user approach was aligned with the European case law and was said to import notions of what's about in the market, what has been about in the recent past. It didn't require an archival mind or eye or more than the average memory, but it did demand some awareness of the product and trends and availability. So in a 2008 case in Australia called the Redbury case, which involved a dress design, the court said an informed user required the following elements, being a person who is familiar with the product to which the design in question relates. They had to be a user of the class of products in question. So that meant that a designer or manufacturer of ladies' clothes was not an informed user merely because they designed or manufactured them. A user would include a potential person. It could include purchases at the wholesale, retail, customer levels. And focus was on eye appeal and not on internal or less visible manufacturing features. So that was one line of authority we had, but then another line said, no, it's not the informed user, it's the familiar person. Although our legislation referred to the informed user, that was really just the tag. And actually the test really was the familiar person. And it didn't mean that you were limited to just a user of the product in question. So we finally resolved that conflict, that divergence in Australia. We've had amendments this year to the Designs Act that came into force in September, and we now most definitely have the familiar person test. So that's the identity of the expert. I guess the next thing is, well, what evidence will you need to obtain from that expert on the question, quite often of distinctiveness? Again, the legislation and case law in your jurisdiction will guide you, with the law differing from country to country and meaning that different results may arise from country to country. In Australia, the overall impression is key to the analysis of distinctiveness, but the comparison is not based on a fleeting or casual inspection or some sort of imperfect recollection of either the design or the allegedly infringing product. There needs to be what's called a studied comparison. Now, in Australia, we get some guidance from the legislation as to what are the relevant considerations for distinctiveness that the court needs to look at. And these include, well, quite obviously, what are the similarities and differences between the designs? But in Australia, more emphasis is given to similarities than differences. That's not the case in all jurisdictions. And also it's important to put on evidence from the expert as to the state of development of the prior art base for the design. In Australia, we also have the ability to file what's called a statement of newness and distinctiveness with the design application. And if the design application has such a statement, then regard is had to that. And that would obviously be relevant to consider with your expert evidence. So on that note, I will hand over to Binchen to talk about authority issued reports.
Thanks, Helen. So evidence serving similar purpose as Helen just described might be required or better to have among other AP countries as well. So for example, in China, as Abe pointed out earlier, a validity assessment report from the patent office is required to do enforcement. However, for infringement, it's actually heavily rely on both parties' arguments and the court's judgment. And in Vietnam, a comparison report from the Vietnam IP Research Institute could be a strong evidence to prove the infringement. So be mindful and check with your local counsel on what kind of authority report or a similar report from the reputable institutes could be a helpful evidence for your case. Thanks, Helen.
Okay, thanks, Binchen. So I think, yeah, our last polling question. Do you keep evidence as to the creation and evolution of new product design? Okay, so the majority has it that you do keep evidence as to the creation and evolution of new product designs. Look, that's great, because while it might not seem important during the exciting launch of a new product, it can be vital when it comes to litigation down the line. So moving on. The second type of evidence that we wanted to cover today, so we've covered first expert evidence, is survey evidence. So is it necessary and how to prepare it? Survey evidence should always be considered. It can be relevant to issues of distinctiveness and confusion. Moving to the next slide. As a preliminary matter, you obviously first need to identify who can conduct the survey. So identifying an independent and recognised research institute or company, and scoping out with them what needs to be done. You know, most importantly, that this is a survey that will be submitted as evidence in court. So the report will need to be filed either as attached to an affidavit or in the form of an affidavit. So, you know, who could be the person that from that organisation that could testify when submitting that report to the court. So that's the preliminary sort of matters I wanted to cover. You'll then need to work out obviously how to conduct the survey. And it's well recognised that the way in which the survey evidence is assembled can lead to it not being admitted into evidence or being given little or no weight. So you really do need to craft your survey very carefully so that you don't fall into that rather large pitfall. In Australia, the court's view is that any party seeking to rely on survey evidence has a responsibility to take appropriate steps to ensure that the survey that is proposed to be conducted will be properly designed and executed, and that the data obtained will be properly recorded and analysed. A party that fails to satisfy the court that it has done these things may find not only that the survey evidence is excluded or given little or no weight, but that it is also required to pay the other party's costs of responding to the survey evidence, even if it is otherwise successful in the proceeding. And that cost consequence obviously would only apply in a jurisdiction where you have costs, and Australia is one of those jurisdictions where costs can be awarded by the court. So because of these difficulties, the Federal Court in Australia has actually issued a practice note setting out a procedure for the giving of notice of a party's intention to adduce survey evidence. And it's for two reasons, both to help the party that wants to do the survey and for the party that's going to respond to the survey. First, to ensure that the other party is given a meaningful opportunity to respond by raising any issues it may have in relation to the proposed survey design or methodology and or the relevance of any results that may be obtained to matters in issue in the proceeding before the survey is conducted, and to provide a party wishing to rely upon survey evidence with some guidance in relation to matters relevant to the survey process and design that may bear on the admissibility of such evidence or the weight that it might be given if admitted into evidence. Now, in terms of the process, there are a range of issues that you need to consider so that the report produced is credible. These include adequately identifying what it is that the survey is designed to measure, not using biased or leading questions, not using questions open to different interpretations or which are poorly defined or ambiguous in terms of concepts, not using a survey instrument that's excessive in length or complexity, adequate testing of the survey instrument, use of a sample frame that's sufficiently representative of the target population, use of an adequate sample size, appropriate and good quality recording and or coding of responses, avoiding excessive non-response and or non-completion rates, appropriate and good quality data analysis, use of researchers for interviewing and or coding of responses with sufficient training or experience, and adequate quality controls. So, you know, in terms of ensuring that you review data for evidence of problems with the participants' understanding of questions. You ensure you've got reliability of recordings, coding of responses, etc. So they're the sort of issues that you need to consider in order to get the process right, so that when you produce the report, and moving to the next slide, if you get it right, then basically what you've got is, you know, strong, you know, credible, persuasive evidence. It provides a starting point. In the absence of other positive evidence, it can contribute to a favourable court's impression, and it can be used in rebutting the evidence lodged by the other counterparty. So the bottom line with survey evidence is it does take a lot of care and thought to get it right. But if you do get it right, it can be a very important piece of evidence to defend your case. I'll hand over to Binsham to finish this last section.
Thanks, Helen. So next one, please. And there are some additional supporting evidence for the parties to consider. Next one, please. So first, for example, creative idea records, which can be useful to prove the distinctiveness or the originality of your design if down the road there is a dispute. And for the product of photo or videos, which can show the complete appearance of the product, will be a solid evidence to prove the infringement. And documentation and access to the registered design could be used as to prove the willful infringement. And the sales record, of course, that can be a strong evidence for the damage. So that's actually end up my section out here. And Helen, back to you.
Thanks, Binchen. So if you haven't had a chance and you would like to, please do post some questions in the Q&A function. I do have a question to start with, is how do you protect the sharing of prototype products with third parties, so like manufacturers, before deciding which one you will register as a design? That might be something I hand over to Victoria and Abe to talk about.
Yes, thank you, Helen. I'll take this one. Well, as I mentioned, if you need, sometimes it's necessary to share embodiments or the prototype with somebody with a view to commercialize it before it has been filed. And it is strongly recommended that you do so under confidentiality agreements or memorandums of understanding, where it is clear to the person that you have disclosed the design that you are doing so on confidential basis and that they should not disclose the design to anybody else. If that party discloses the design, you will get protection from that disclosure in most jurisdictions under a grace period for filing. Thank you.
Is there anything you'd like to add there? I'm going to take that as a no. So look, another question that we have is about the average costs of registrations compared to trademarks and patents. Who'd like to take that question? Is that something Abe or Victoria again?
I can certainly take that from the perspective of patents. So I think when it comes to registration costs for designs versus patents, there is quite a big difference. As you may know, for those who have pursued patent protection in the past, pursuing patent protection requires quite a bit of work. You'll require drafting of a patent specification, performing prior art search analysis, followed by filing of patent applications in all jurisdictions. When it comes to design, the cost for preparation and registration is considerably less, especially in view of the fact that a full patent specification doesn't need to be drafted for design. What you do have to ensure is, as Victoria had mentioned in her session, the proper views as well as the types of and quality of images and drawings that will be filed as part of the design application.
Yes, if I may add, in relation to the cost of trademarks, it will depend. Sometimes it could be less or it could be more, depending on primarily your trademark application will need to be filed in respect of certain goods or services. And depending on how many classes those goods and services fall, your cost will increase the more classes you add. The design, the same design, if you file it in relation to a number of different products within the same Locarno class, may not necessarily incur additional official fees. And the cost of registration are relatively low, around the same compared to the trademarks.
Thank you, Victoria. So another question we've had is, what is a customs notice in the context of registered designs? Joanna, Abe, Victoria, would you like to, one of you like to take that question?
I'm not sure if you, I can certainly take that. Yeah, so
Sure.
certain jurisdictions, Yeah, so certain jurisdictions will allow for customs notices whereby you can actually request for a seizure of goods, infringing goods coming into the country as well. As I mentioned earlier, there are certain countries that allow that, but at the same time, there are countries that are in the process or don't have that. Singapore has recently enacted that, and I believe sometime next year, there will be an allowance for customs notices. Joanna and Victoria, I'm not sure if you want to mention from the perspective of your respective countries.
Yeah, Australia doesn't have customs notice procedures for design registrations yet.
Yeah, so in China, we have this customer protection in general for all type of patents, and the design is one of the type which actually relatively easier for the customer to take actions. So we do need to do recordal, and then with the customs, then the customs gonna make a monitoring, and when there is a suspicious shipment, the custom gonna notify the patentee. Yeah.
Thanks, Binchen.
Yes, in Taiwan as well, that we have custom enforcement, just like I mentioned in the presentation, that you can request to detain the infringing products. And the procedures that you have to make application in writing, and you also have to establish that it's highly likely that it's infringing. And most importantly, you will be required to post a bond. Yeah.
Thanks, Joanna. And then one last question before we sign off. This is about the line between design and copyright infringement when it comes to copying a piece of clothing. Where to draw the line? That's a bit of a big question. Binchen, I don't know whether you'd like to answer it from the China perspective.
So sure. So for copyright, I think clothing is actually has been a long debate in China whether it's protectable or not. There are some cases start to emerge from the judicial branch. I think we are evolving to the direction of give certain type of protection under the copyright law for this clothing patents. And the difference between design and copyright is that design actually relatively has a much higher requirement in terms of novelty and distinctiveness. And for copyright, it's more about the originality. So that would be the difference, I would say.
If I may add,
Please.
This is one of the areas where you need to be aware that in Australia, for example, whilst copyright in principle will subsist in the clothing pattern, by applying that clothing pattern to a dress and by selling more than 50 pieces of dresses that is to be industrially applied, your copyright on the pattern will not be enforceable against another piece of clothing that copies that design, because Australia does not recognize the double protection, or the legislation in Australia is to avoid double protection in these instances. And this is where we see many of our clients fall because they don't know that copyright doesn't subsist, and they generally rely on copyright to enforce in a lot of items of fashion, including bags, shoes, and clothing. Something to be aware.
Yeah. Thank you, Victoria. So look, thank you to our speakers for sharing their insight and experience on these topics. We've come to the end of our session today. If you have any questions, please send them. Well, actually, we've sent them through. So look, if you have any questions further, please do let us know. Our Litigating Designs webinar series is a global one. So if you are interested to attend our other sessions, specifically for North America, Latin America, and EMEA, please scan the QR code and register in the Litigating Design registration page. And so once again, thank you for joining us, and we hope to see you again soon. Bye.